efficient. Negotiable Instrument Act of 1881 as amended in 1882, Part 5. Bill of Exchange Act. When notary not accessible. Protest continued. When notary not accessible. 122. Where a dishonored bill is authorized or required to be protested and the service of a notary cannot be obtained at the place where the bill is dishonored, any justice of the peace resident in the place may present and protest the bill and give all necessary notice and has all the necessary powers of a notary with respect thereto. Expense. 123. 1. The expense of noting and protesting any bill and the postage thereby incurred shall be allowed and paid to the holder in addition to any interest thereon. Notary's fees. 2. Notaries may charge the fees in each province allowed them. Forms. 124.1. Let's go back here. Notary's fees. I got hemmed up on this one time. I cultivated a notary. She's a good friend of ours. And we went to court trying to bring suit, and the judge asked to see the notary logbook, which she provided. And because we had not paid the notary, okay, the notary appeared to be biased and they discharged our claim. Always pay your notary, always get receipts, and then get a certified copy of their logbook where they log your data in it for the protest. Very, very key. It's quintessential to make sure to pay your notary. Don't care if it's $1, don't care if it's $50, whatever it is, make sure to do that. Okay? Forms. 124.1. The forms in the schedule may be used in noting or protesting any bill and in giving notice thereof. Annexing copy or original of bill. 2. A copy of the bill and endorsement may be included in the forms, or the original bill may be annexed and the necessary changes in that behalf made in the forms. How notice of protest given. 125. Notice of protest of any bill payable in Canada is sufficiently given and is sufficient and deemed to have been duly given and served. If given during the day on which protest has been made or on the next following judicial or business day, the same parties and in the same manner and addressed in the same way as if provided by this part for notice of dishonor. Liabilities of parties. Equitable assignment. 126. A bill of itself does not operate as an assignment of funds in the hands of the drawee available for the payment thereof, and the drawee of a bill who does not accept as required by this act is not liable on the instrument. Engagement by acceptance. 127. The acceptor of a bill, by accepting it, engages that he will pay it according to the tenor of his acceptance. Estoppel. 128. The acceptor of a bill, by accepting it, is precluded from denying to a holder in due course: A. The existence of the drawer, the genuineness of his signature, and his capacity and authority to draw the bill. B. In the case of a bill payable to drawer's order, the capacity of the drawer to endorse, but not the genuineness or validity of his endorsement. Or C. In the case of a bill payable to the order of a third person, the existence of the payee and his then capacity to endorse, but not the genuineness or validity of his endorsement. The reason this is so important, ladies and gentlemen, is because it's a paper for paper exchange. There is no money, okay? The gold and silver has been taken out of the economy in almost the entire world as far as countries are concerned. Okay, so it's all just paper for paper. It's notice and acceptance, it's presentments, It's honor and dishonor. That's it. That's all it can be. There's nothing else. It's paper for paper, okay? And so it's important to understand that. You'll notice throughout this was created in 1881. They still had gold and silver out back then. So payment was a little bit different. As today, as far as it stands, there is no requirement for a specific species because everything is paper exchange for paper exchange, promises to pay something sometime in the future, okay? Drawer, 129. The drawer of a bill, by drawing it, A, engages that on due presentment it shall be accepted and paid according to its tenor, and that if it is dishonored, he will compensate the holder of any endorser who is compelled to pay it, if the requisite proceedings on dishonor are duly taken, and B, is precluded from denying to a holder in due course the existence of the payee and his then capacity to endorse. Liability by signature, 130. No person is liable as drawer, endorser, or acceptor of a bill who has not signed it as such, but when a person signs a bill otherwise than as a drawer or acceptor, he thereby incurs the liability of an endorser to a holder in due course and is subject to all the provisions of this act respecting endorsers. Trade name or assumed name. 131.1. Where a person signs a bill in a trade name or assumed name, he is liable thereon as if he had signed it in his own name. Firm name. The signature of a name of a firm is equivalent to the signature by the person so signing of the names of all persons liable as partners in that firm. Endorser. 132. The endorser of a bill, by endorsing it, subject to the effect of any express stipulations authorized by this act, A, engages that on due presentment it shall be accepted and paid according to its tenor, and that if it is dishonored, he will compensate the holder or a subsequent endorser who is compelled to pay it, if the requisite proceedings on dishonor are duly taken. B, is precluded from denying to a holder in due course the genuineness and regularity in all respects of the drawer signature and all previous endorsements, and C, is precluded from denying to his immediate or a subsequent endorsee that the bill was, at the time of his endorsement, a valid and subsisting bill, and that he had then a good title thereto. Measure of damage. 133. Where a bill is dishonored, the measure of damages, which shall be deemed to be liquidated damages, are A, the amount of the bill, B, interest thereon from the time of presentment for payment, if the bill is payable on demand, and from the maturity of the bill in any other case, and C, the expenses of noting and protesting. Recovery of damages. 134. In the case of a bill that has been dishonored, the holder may recover from any party liable on the bill. The drawer who has been compelled to pay the bill may recover from the acceptor, and an endorser who has been compelled to pay the bill may recover from the acceptor or from the drawer or from a prior endorser the damages prescribed in sections 133. Re-exchange and interest. 135. In the case of a bill that has been dishonored abroad, in addition to the damages prescribed in sections 133, the holder may recover from the drawer or any endorser, and the drawer or an endorser who has been compelled to pay the bill may recover from any party liable to him the amount of the re-exchange with interest thereon until the time of payment. Transfer by delivery. 136.1. Where the holder of a bill payable to bearer negotiates it by delivery without endorsing it, he is called a transferor by delivery. Liability of transferor. A transferor by delivery is not liable on the instrument. Warranty by transferor. A transferor by delivery who negotiates a bill thereby warrants to his immediate transferee, being a holder for value, that A, the bill is what it purports to be, B, he has a right to transfer it, and C, At the time of transfer, he is not aware of any fact that renders it valueless. Discharge of bill. Payment. 138. A bill is discharged by payment in due course by or on behalf of the drawee or acceptor. Payment in due course. Payment in due course means payment made at or after the maturity of the bill to the holder thereof in good faith and without notice that his title to the bill is defective. Accommodation bill. Where an accommodation bill is paid in due course by the party accommodated, the bill is discharged. Payment by drawer or endorser. 139. Subject to the provisions of Section 138 with respect to the accommodation bill, when a bill is paid by the drawer or endorser, it is not discharged, but A, where a bill payable to or to the order of a third party is paid by the drawer may enforce payment thereof against the acceptor, but may not reissue the bill. And B, where a bill is paid by an endorser or where a bill payable to drawer's order is paid by the drawer, the party paying it is remitted to his former rights as regards the acceptor or antecedent parties, and he may, if he thinks fit, strike out his own and subsequent endorsement and again negotiate the bill. Acceptor holding at maturity. 140. When the acceptor of a bill is or becomes the holder of it at or after its maturity, in his own right, the bill is discharged. Renouncing rights. 141. When the holder of a bill at or after its maturity absolutely and unconditionally renounces his rights against the acceptor, the bill is discharged. Against one party. 2. The liabilities of any party to a bill may in like manner be renounced by the holder before, at, or after its maturity. In writing. A renunciation must be in writing unless the bill is delivered to the acceptor. Holder in due course. Nothing in this section affects the rights of a holder in due course without notice of renunciation. Cancellation of bill. 142. Where a bill is intentionally canceled by the holder or his agent and the cancellation is apparent thereon, the bill is discharged. Of any signature. 2. In like manner, any party liable on a bill may be discharged by the intentional cancellation of his signature by the holder or his agent. Discharge of endorser. 3. In any case described in subsection 2, any endorser who would have had a right of recourse against the party whose signature is canceled is also discharged. Unintentional cancellation. 143. The cancellation made unintentionally or under a mistake or without the authority of the holder is inoperative, but where a bill or any signature thereon appears to have been canceled, the burden of proof lies on the party who alleges that the cancellation was made unintentionally or under mistake or without authority. Alteration of a bill. 144. 1. Subject to subsection 2, where a bill or an acceptance is materially altered without the assent of all parties liable on the bill is void, except as against a party who has himself made, authorized, or assented to the alterations and subsequent endorsers. Right of holder in due course. Where a bill be materially altered, but the alteration is not apparent, and the bill is in the hands of a holder in due course, the holder may avail himself of the bill as if it had not been altered and may enforce payment of it according to its original tenor. Material alteration. 145. In particular, any alteration, A, of the date, B, of the sum payable, C, of the time of payment, D, of the place of payment, or E, by the addition of a place of payment without the acceptor's assent, where a bill has been accepted generally, is a material alteration. Acceptance and payment for honor. Acceptance for honor under protest. Where a bill of exchange has been protested for dishonor by non-acceptance, or protested for better security, and is not overdue, any person not being a party already liable thereon may, with the consent of the holder, intervene and accept the bill under protest for the honor of any party liable thereon, or for the honor of the person for whose account the bill is drawn. In Part 147, a bill may be accepted for honor for part only of the sum for which it is drawn. Deemed to be for honor of drawer 148, where an acceptance for honor does not expressly state for whose honor it is made, it is deemed to be an acceptance for the honor of the drawer. Maturity of after sight bill. Where a bill payable after sight is accepted for honor, its maturity is calculated from the date of protesting for a non-acceptance and not from the date of the acceptance for honor. Requirements 150. An acceptance for honor under protest, in order to be valid, must be A. Written on the bill and indicated that it is an acceptance for honor, and B. Signed by the acceptor for honor. Liability of the acceptor for honor 151. The acceptor for honor of a bill, by accepting it, engages that he will, on due presentment, pay the bill according to the tenor of his acceptance. If it is not paid by the drawee, if it has been duly presented for payment and protested for non-payment, and if he receives notice of those facts. Liability to holder and others. 2. The acceptor for honor is liable to the holder and to all parties to the bill subsequent to the party for whose honor he has accepted.